Today I'll be discussing two legal cases at the center of which are controversial searches of students on school property. This type of case is of particular interest and importance to me, as I'm a strong believer in the proper administration of justice and a strong believer in the fact that it is better to let 100 guilty persons go free than to convict one innocent person. Indeed, I believe this to be a cornerstone of our justice system, and that the upholding of this principle is one of our best defenses against sliding down a slippery slope to a police state, where no one is really safe from being arbitrarily searched, detained, arrested, or jailed. The fact that in schools, as we will see, it has been determined in case law that a warrant is not required makes this even more interesting to me, especially as a teacher candidate. I've always felt as though the rights of minors and students are an interesting gray area. In the first case, which you can find under my reference list as R versus MA 2004, the police, responding to an open invitation from the principal to come and search the school, arrived without warning with this purpose in mind. Upon their arrival, the principal announced upon the PA that this search would be taking place and told everyone to stay in their classrooms. The police searched the school with drug-sniffing dogs, including lockers and bags in the gym. When the dogs took an interest in one student's bag, an officer searched it and found marijuana and mushrooms. The student was arrested. However, when the case went to court, the judge ruled that the evidence was to be excluded. This was his reasoning. Although a warrant is not required to search students in the school, there is a reduced expectation of privacy because teachers have to maintain order and discipline and are expected to act quickly to keep students safe, there still needs to be reasonable grounds to conduct a search. Section 8 of the Canadian Charter of Rights and Freedoms states that everyone has the right to be secure against unreasonable search or seizure. The principal and police were not acting on specific information that the student had illegal drugs in his possession, but rather on the assumption that in a large school it was likely that drugs were present. In the following quote from the judge, he refers to a case which he calls MRM. In the reference list, you can find it as R versus MMR 1998. The judge stated that, and I quote, "While some flexibility must be extended to school authorities with respect to what information will give them reasonable grounds, I do not believe the intent of the Supreme Court in MRM is to allow a reasonably well-educated guess to constitute reasonable grounds. The likelihood of drugs being present in the school would seem to be as great now as it was in 1998 when the Supreme Court upheld the requirement for reasonable grounds as part of a search in the school setting." In other words, this was not good enough reason to conduct a search. The judge further concluded that the charter rights of the defendant were violated, along with the charter rights of every other student in the school. For this reason, the evidence was excluded from the case. The second case, which you can find in the reference list as R versus Thanganadan 2004, took place at an adult night school. The defendant was accused of possession of counterfeit money. While in class one night, the teacher noticed the defendant sitting closely and laughing with a couple of classmates while holding colored paper that appeared to be money. He approached the group and asked them, and I quote, what was going on, to which the defendant replied, and I quote, nothing. The teacher left them alone. A few minutes later, he asked the defendant to step outside. Once outside the classroom, the teacher asked the defendant if the money in his pockets was counterfeit. The defendant replied, and I quote, not all of it. The teacher then confiscated the money and reported it to the police. As in the previous case, the defense argued that the evidence was obtained in breach of Section 8 of the Charter and should be excluded. The judge agreed. He stated that the defendant had a reasonable expectation of privacy as it was an adult night class, which the defendant had no obligation to stay in. He further stated that the teacher used his position of authority to get a confession of guilt from the student who believed he would be expelled if he did not comply with the teacher, incriminate himself, and hand over the money. The teacher did not have reasonable grounds to conduct a search, and although technically no search was conducted, the evidence was considered derivative. According to the judge, and I quote, this is a subsection of conscriptive evidence, and the unlawfully conscripted statement of the accused is the necessary cause of the discovery of the real evidence. The teacher questioning was unlawful, as he conducted it only based on a vague suspicion and was not doing anything with the purpose of maintaining order in the classroom. The teacher admitted that the initial incident took place before the class actually began, and also admitted that he did not have reasonable grounds, only a mere suspicion that something was going on. According to the judge, based on previous case law, there is a modified standard with which the charter is applied. In essence, as I stated in the above case, a warrant is not required for a search, but reasonable grounds based on concrete information are required. These grounds were not satisfied in this case, and for this reason, the evidence was excluded. These cases are significant for me as an Ontario teacher, or a future Ontario teacher, because they are a reminder that, although I will be responsible for maintaining order in my classroom and school, I still have to respect the legal and charter rights of my students. I also believe that these two cases can be applied to the Ontario College of Teachers Act on professional misconduct. Subsection 5 says that professional misconduct includes not upholding the standards of the profession. The OCT standards of practice, under the section of commitment to students and student learning, state that teachers should treat students equitably and with respect. I think that, therefore, it behooves us as educators to hold our students' charter rights in very high regard and ensure that we do not breach them. Another matter for consideration is that the Child and Family Services Act has a definition of abuse, which, when used in reference to a child, means that the child is in need of protection. In the first case discussed, the charter rights of a whole school full of children were violated, and I would argue that these children were in need of protection from the principal and from the police. Although I doubt that anyone would call CAS in this case, this is still something worth considering. Well, that's all for these case comparisons. Thank you very much for listening.